Two lawyers are now threatening to sue each other over Nolan Wells, not over what happened on Horn Island, over what people are allowed to say about it afterward, in comment sections and on commentary channels just like this one. And by the end of this video, you'll understand why that fight might end up mattering just as much as the case itself. At the time this video was recorded, it had been 27 days since Nolan disappeared, and this week brought the loudest, most consequential update since his funeral. This week's update came as a legal strategy shift, a named friend finally speaking through his own attorney, and two other families stepping into the spotlight beside Nolan's, all inside the same room in Nashville, on the same stage in front of the same cameras. Let's start with the part that changes the entire shape of this case going forward. Ben Crump confirmed that Nolan's family has begun sending legal preservation notices, formal demands ordering specific individuals to hold on to text messages, photographs, videos, and social media activity. Ahead of a civil lawsuit the family is now actively preparing to file. That's a real shift. For a month, this case has moved through press conferences, funerals, and public pressure campaigns. A lawsuit is a different animal entirely. One with subpoena power, sworn depositions, and a discovery process that can force answers no press conference ever could. Depositions in particular tend to matter more than people expect, because a sworn statement given under oath carries consequences a public comment never will. Lying to a reporter costs nothing legally. Lying in a deposition can become its own separate crime. A preservation notice is a formal legal instrument, and once someone receives one, deleting covered material becomes its own separate legal violation, spoliation of evidence, regardless of whether a criminal case ever moves forward. If the criminal investigation continues at its current pace, a civil case could end up being the faster path to sworn, on the record answers, even if it can never result in criminal charges on its own. Bart Edmiston Jr., the former teammate whose name surfaced after that leaked emergency call, has now spoken publicly for the first time through his own attorney. He denies any involvement in Nolan's death. He says he's received death threats despite cooperating fully with investigators from the very beginning. And here's the detail that flips the entire dynamic of this story. Edmiston is now considering his own defamation lawsuit against the people spreading accusations about him online. His family says they're prepared to do the same. It's a strange position to be in, cooperating with investigators on one side while bracing for accusations from strangers on the other, and it's the kind of pressure that rarely gets discussed when this case gets reduced to a single villain narrative online. Before this week, everything connecting him to public suspicion came from second-hand interpretation of that leaked audio. A name shouted in apparent panic, amplified by commentary channels with no direct connection to him at all. Now, for the first time, there's an actual statement from his own legal representation, on the record, responding directly to those accusations. That's a meaningful shift in the reliability of what we can responsibly report about him. That name's own attorney is now pushing back specifically and formally against the kind of amplification that's followed him online. Sit with that for a second, because it's not a small development. For weeks, this series has tracked one direction of legal pressure, a grieving family pushing for accountability against people they believe are withholding answers. Now there's a second front opening in the opposite direction, a named cooperating witness preparing to sue the internet itself for what's been said about him. Both of those legal threats can be entirely legitimate at the same time. A family has every right to demand transparency. A person who's cooperated fully and been accused of murder online without a shred of official evidence has every right to defend his name too. This case isn't just about what happened to Nolan anymore. It's becoming a live argument about who gets to say what publicly before anyone truly knows the answer. And that argument is now generating its own separate legal consequences, independent of whatever the underlying truth about Nolan's death turns out to be. That tension boiled over during the press conference itself. A reporter from the New York Post directly asked Crump about a threat to sue him and Nolan's family for defamation. Crump's response was immediate and dismissive, calling it a distraction not worth dignifying, and saying flatly that he and his team won't be sidetracked by it. Christine Wonsley backed him up, saying the same thing in fewer words. We're not distracted by it at all. Whether you think that dismissal is fair or evasive probably depends on which side of this fight you were already standing on before this week even started. I think it's worth noting how visibly tense that specific exchange really was, because it wasn't a routine question and answer. Crump pushed back hard against the framing of the question itself, at one point comparing the reporter's line of questioning to a familiar pattern he says he's seen for years, where a family's pursuit of answers for a dead child gets reframed publicly as a cynical grab for attention or money. He was direct that he believes any lawyer, civil rights or otherwise, is entitled to be compensated for their work, the same as any other attorney in any other field, and that questioning his motives simply because this case involves race is itself part of the exact pattern he's trying to call out. This update also widens far beyond Mississippi entirely, and it's the part that deserves the most attention tonight. Crump didn't come to Nashville to talk about Nolan alone. He brought two other families onto that same stage, and the pattern he's drawing between all three cases is the most direct argument he's made yet. Daniel Irving was 18, an honor roll student and a swimmer from outside Dallas. On April 13th, he went to a lake with two white teenagers and never came home. His body was recovered 4 days later. According to Crump, those two friends threw away Irving's phone, threw away his clothes, and deleted their own text messages with him, then said nothing to anyone, not his mother, not investigators, for months. It was only after Irving's mother, Tamika, pushed publicly and activists in Dallas got involved that the two friends finally came forward and admitted what they'd done. They were arrested and charged 3 months later, only with tampering with evidence, not with his death. Crump's team also pointed to something else in Irving's case that never made it into the official investigation the way it should have, something that echoes almost exactly the frustrations Nolan's own family has voiced from the very first week. A witness reportedly told investigators that one of the young men was limping when he returned from the lake that day, a detail Irving's mother has specifically questioned, since if her son simply jumped or fell, why would anyone else involved be left with an injury like that at all? Attorney Sean Dara, representing the Irving family, said a witness even provided video footage on a flash drive to detectives, and that footage was never entered into the probable cause affidavit at all. Irving's mother doesn't believe her son, a strong swimmer with no history of recklessness, went into that water unforced. She's asking plainly why that limping detail and that video were never pursued. Tyler Smith was also 18, from Lexington, Kentucky, the only black person at a small house party on the same 4th of July that Nolan disappeared. Somehow he ended up shot in the head. The surviving friends told police it was an accident, that they'd been playing Russian roulette. Police took that explanation and, according to Crump, never tested anyone's hands for gunshot residue, standard practice in literally any shooting death. When the gun they eventually produced didn't match the shell casings found at the scene. Investigators had to go back and surround one friend's house before he finally came forward with the actual weapon. Once again, the only charges filed were for tampering with evidence, not for causing Tyler's death. It took investigators a full 7 days after that shooting to even identify everyone who'd been in that house at the time, according to Crump's team, before they could even begin tracking down which specific weapon had even been used to kill him. A teenager is shot dead in a house full of people, and it takes a week just to establish who was present, let alone what happened. A full week is an enormous amount of time in an investigation like this. Memories fade, people talk to each other and align their stories, and evidence that could have been collected in the first 48 hours simply stops existing by the time anyone thinks to ask for it. Tyler's mother and grandmother have been the driving force behind pushing that case forward, the same way Christine and Elmore have driven Nolan's, and Crump said plainly that new information is starting to come forward in Tyler's case too. Directly because of the national attention Nolan's case has generated, a family's fight for their own son is now pulling other stalled cases back into motion, simply because more people are paying attention to how these investigations tend to unfold. Notice the shape of all three of these stories side by side, because it's the same shape every time. A black teenager dies under circumstances that don't add up. The people who are with him handle physical evidence in ways that look deliberate rather than accidental. Investigators accept an early, convenient explanation without basic verification. And the only charges that ever materialize, if any do at all, land on the evidence tampering itself, never on the death. Crump's argument isn't that these three cases are legally connected. They aren't. Different states, different families, different lawyers. His argument is that this specific pattern keeps repeating, and that putting all three families on one stage together is the only way to make that repetition impossible to ignore. There's a strong counter-argument to that framing worth laying out. Three cases sharing a surface-level pattern, a young black victim, evidence handled strangely, an initial charge limited to tampering rather than homicide, doesn't prove those three deaths share an actual cause or that any of the surviving friends in any of the three cases did something criminal to cause them. Evidence tampering charges alone could reflect panicked, poor decisions made by scared teenagers who didn't cause a death but made it look worse by mishandling what came after. Exactly the kind of thing that happens even in genuine accidents when young people don't know how to respond to sudden tragedy. Both readings of this pattern are genuinely available to you right now, and neither one is proven yet in any of these three separate cases. It's worth holding both of those possibilities in your head at once, because certainty in either direction right now would be getting ahead of what's been proven in any of these three cases so far. That Nashville room was deliberately emotional, not just lawyers reciting facts. Tyler Smith's grandmother and mother were there. Daniel Irving's mother, Tamika, stood beside Christine and Elmore. Attorney Lisa Park told the room they're now getting over 100 calls a day on the tip line, and that for every person calling in to spread hate, someone else is calling in with real information or real encouragement. That's the actual texture of what a case like this looks like from the inside, not a tidy press release, but a room full of grieving parents leaning on each other because almost nobody else in their lives can understand what they're going through. That ratio matters more than it might seem at first, because it means the volume of public attention hasn't simply produced noise, it's produced real leads mixed in with the hostility, and sorting through that mix is its own quiet, unglamorous part of this investigation. Park made a direct appeal during her remarks aimed specifically at anyone who's hesitated to come forward so far. She acknowledged plainly that people calling in with information are scared, and told them clearly that if there's ever a moment in your life to be brave and do the right thing, this is it. It's a direct plea to somebody watching this video right now, somebody who is on that island or at that lake or in that house, who's been sitting on a piece of information out of fear rather than indifference. There's real concrete movement in the actual investigation too, not just rhetoric. Attorney Eric Hertz confirmed that Jackson County District Attorney Angel Myers McElrath sent the family's legal team a letter agreeing to at least listen to some of the evidence they've gathered independently. There's a tentative agreement forming for a joint examination of the phones connected to this case, plural, not just Nolan's, with investigators from both sides examining them together. And Hertz said he believes the F. B, I will be present for that process as well. A letter like that doesn't guarantee anything by itself, but it does mean the family's independent evidence is no longer being ignored entirely, and that in itself is a meaningful crack in a wall that's stayed shut for most of this investigation. That's the most concrete sign yet that the wall between the family's private investigation and the official one might finally be coming down, even if only partially. This represents real forward motion, but it's still just a tentative agreement without a confirmed date. The district attorney's office has up to this point, kept nearly everything about its own investigation out of public view, citing the integrity of the eventual grand jury process. A willingness to listen to some evidence and a tentative agreement to coordinate on phones is a real, documented shift in posture from an office that's mostly stayed silent for weeks. But tentative isn't the same as scheduled, and listen isn't the same as act. Whether this produces anything concrete in the end depends entirely on what happens in the days after this letter, not on the letter itself. There's another thread here that hasn't gotten nearly enough attention, and it might end up mattering more than anything said from that podium. Crump's team has now retained what he described as some of the foremost audio engineering experts in the country to formally review the entire CTAL recording. Not an amateur audio enhancement circulating online, but a retained professional review of the complete call, conducted by people whose findings could be presented as expert testimony rather than a viral clip picked apart by strangers. Separately, his team is consulting oceanic engineering experts specifically to examine the tides and currents around Horn Island, trying to determine whether it makes real physical sense for Nolan's body to have been found in the same location where his friends say they last left him. Water moves, and a body in open water off a barrier island doesn't simply sit in place for 2 days. It drifts with currents, tides, and wind, sometimes for miles depending on conditions. If Nolan's body was recovered essentially where his friends claim he was last seen, that's either a coincidence explainable by specific local tidal patterns that day, or a detail that doesn't line up with how water moves in that stretch of the Gulf. If the currents don't support that location matching, that becomes hard, verifiable physics, exactly the kind of science this case has been missing since day one. That's the kind of finding that could either quietly support the account given by Nolan's friends or quietly contradict it, and either way it would be based on physical measurement rather than speculation from people who weren't there. Crump also mentioned something almost in passing that connects directly to the missing neck structures from Nolan's independent autopsy. He said his team is trying to coordinate with Dr. Roger Mitchell to gain access to those retained structures, and separately to obtain the original photographs and observations documented by the state's examiner back when Nolan's body was first recovered, before decomposition and dissection made so much of that information unrecoverable. If that access ever happens, it would be the first real bridge built between the independent autopsy and whatever the state already knows and hasn't released, closing a gap that sat at the center of this case since the autopsy findings first surfaced. Across an update this dense, it's easy to lose track of the two people this case is really about. Christine Wonsley stood in that room and said something that closes out everything else in this video. It has been 27 days since we have been able to talk to our son, to hug him, to tell him we love him. She described Nolan as someone who made people feel comfortable just by being near him. Someone who'd become your biggest cheerleader the moment you shared even a small piece of your life with him. She said she is not too proud to beg, and that she won't rest until she gets answers, regardless of every distraction, every attack, every negative review someone's posted on her employer's website since she started asking questions about her son's death. I keep coming back to that specific cruelty, strangers finding a nurse's workplace review page and leaving negative reviews there, apparently as punishment for a mother publicly grieving her son. Crump addressed it directly at the podium, pointing out that Christine has worked as a nurse for years without ever facing that kind of backlash before, and that it only started once she began asking questions about how her son died. That's not political disagreement or skepticism about the case. That's a targeted attempt to damage someone's actual livelihood, and it tells you something uncomfortable about how much collateral damage a case this large can generate on every side of it. Not just toward the friends who've received death threats, but toward a grieving mother simply trying to keep her job intact while she fights for answers. Elmore spoke too, more quietly than his wife had, describing the fresh challenge of simply waking up every morning and trying to process what's happened. He said he and his wife raised Nolan to love everyone and be kind to everyone because it was simply the right thing to do. And that no parent, regardless of race, should have to grieve while also being attacked for grieving publicly. He asked a simple question that lingers longer than almost anything else said this week. Where's the empathy at? That kind of grief doesn't pause for legal strategy or press conferences. It just sits there every single day, whether or not a courtroom ever opens. Here's where things stand tonight. A civil lawsuit is being prepared with formal evidence preservation already underway. A named person of interest is now threatening to sue his own accusers, opening a second legal front nobody was tracking a month ago. Two other families with strikingly similar stories have stepped forward specifically because Nolan's case gave them a platform they didn't have on their own. Real forensic and scientific experts, audio engineers, and title specialists are now working this case directly, not just commentators online. And underneath every bit of that noise sits two parents who've now gone nearly a month without hearing their son's voice, standing in front of strangers in Nashville, asking the exact same question they asked on day one. None of these updates, the lawsuit, the defamation threat, the audio experts, the title analysis, changes what a family in Mississippi is living through every single morning they wake up without their son. I want to know what you think moves this case forward faster from here, a civil lawsuit with real subpoena power, or the pattern Crump is drawing between Nolan, Daniel Irving, and Tyler Smith. Does connecting these three cases strengthen the argument that something systemic is happening, or does it risk diluting the specific facts of Nolan's case by folding it into two others, neither of which has been proven to share an actual cause with his death? Bart Edmiston is now threatening his own defamation suit, and that's worth weighing against how you're reading the accusations against him. Tell me what you think in the comments. We'll be back the moment that joint phone examination happens, the moment those oceanic tide findings come back, or the moment either lawsuit, the families, or Edmiston's finally gets filed. Subscribe so you're here for whichever one lands first.